ਜਗਮੋਹਨ ਸਿੰਘ ਭੱਟੀ ਐਡਵੋਕੇਟ YouTube ਚੈਨਲ ਅੱਜ ਤੁਹਾਡੇ ਨਾਲ ਦਿਲ ਦੀਆਂ ਗੱਲਾਂ ਦੇ ਵਿੱਚ ਇਹ ਵੀ ਗੱਲਾਂ ਕਰਨ ਲੱਗਿਆ ਕਿ ਕਿਵੇਂ ਇਹ ਤਿਰੰਗੇ ਦੀ ਆਨ ਬਾਨ ਸ਼ਾਨ ਇਹ ਇਸ ਵੇਲੇ ਪੰਜਾਬ ਐਂਡ ਹਰਿਆਣਾ ਹਾਈ ਕੋਰਟ ਦੇ ਕੈਂਪਸ ਵਿੱਚ ਹਰੇ ਹਰੇ ਦਰਖਤਾਂ ਦੇ ਵਿੱਚੋਂ ਝਾਕ ਰਹੀ ਹੈ ਔਰ ਇਸ ਸ਼ਾਨ ਨੂੰ ਕਿਸ ਤਰ੍ਹਾਂ ਬਰਕਰਾਰ ਰੱਖਿਆ ਜਾ ਸਕਦਾ ਹੈ। ਇਹ ਇੱਕ ਕੰਟਰੋਵਰਸੀ ਦੇਸ਼ ਦੇ ਚਿੰਤਕਾਂ ਦੇ ਵਿੱਚ, ਦੇਸ਼ ਦੇ ਵੱਡੇ ਵੱਡੇ ਕਾਨੂੰਨਦਾਨਾਂ ਦੇ ਵਿੱਚ ਇਹ ਛਿੜ ਚੁੱਕੀ ਹੈ ਕਿ ਸੰਵਿਧਾਨ ਦੀਆਂ ਧੱਜੀਆਂ ਕਿਵੇਂ ਤੇ ਕਿਉਂ ਉੱਡ ਰਹੀਆਂ, ਕਿਸ ਹਿਸਾਬ ਨਾਲ ਉੱਡ ਰਹੀਆਂ। ਓਥ ਜਿਹੜੀ ਲਈ ਜਾਂਦੀ ਹੈ ਸੰਵਿਧਾਨ ਦੇ ਥੱਲੇ, ਜਿਹੜੀ ਸੌਗੰਧ ਚੱਕੀ ਜਾਂਦੀ ਹੈ ਕਿਸੇ ਵੀ ਕੌਂਸਟੀਟਿਊਸ਼ਨਲ ਪੋਸਟ ਦੇ ਵਾਸਤੇ, ਉਸ ਦਾ ਨਿਸ਼ਾਨ ਕਿਵੇਂ ਮਿਟਾਇਆ ਜਾਂਦਾ ਹੈ। ਇਹ ਗੱਲਾਂ ਜਿਹੜੀਆਂ ਤੁਹਾਡੇ ਵਿਚਾਰ ਅਧੀਨ ਹੈ। ਨਾਓ ਟੁਡੇ ਆਈ ਐਮ ਸਪੀਕਿੰਗ ਅਬਾਊਟ second anticipatory bail if it is maintainable in the eyes of law. There are two conflicting decisions of two full benches of the two different high courts. One is from Calcutta High Court, wherein it said that even if the new change in circumstances is coming, then the anticipatory bail in the second petition is not maintainable, whereas at the same time the Rajasthan High Court has stated and held that change in circumstances is maintainable and it is a second anticipatory bail which is to be maintained for the personal liberty and life. Now the Honorable Supreme Court, what it says about the second anticipatory bail, once there are two conflicting decisions of the full benches of the Calcutta High Court as well as the Rajasthan High Court, then the situation is prevailingly different in the country high courts. And some high courts are saying even the third anticipatory bail is maintainable, whereas certain high courts are saying the second anticipatory bail is not maintainable and controversy is not put into rest. If the country is not to rest, then the controversy will rest. And how it will rest? By way of violence of privacy, life, liberty and personal liberty, which has been stated by the Honorable Supreme Court of India while enlarging, discussing the scope of 438 CRPC, while taking account of the different countries of the world, wherein it has been stated that the life and liberty of the citizens is a paramount consideration. Why the arrest is made? Arrest need not to be made. Police says arrest is not to be made. Why the arrest is not to be made? It is total and sheer discretion of the police people, police officials, whereas the Honorable High Courts and the Honorable Courts are expressing their inability to grant bail. Then how this system is managed, everybody knows, and it is a time to arrive at a cool decision that our honorable judges of the High Court as well as the Supreme Court are to take into consideration the appreciation of the facts that once the constitutional liberty granted under Article 21 of Constitution of India is not to be demolished and it is to be respected, and even the right to privacy has been respected, then what remains? It is a question again before the high courts. And even I have come across number of subordinate judges of the rank of additional district and session judges, wherein they are saying that where a person has not been even summoned by way of regular course and submitted his bail application, then it is all right. If bail application is not submitted and bail bonds are not executed, then the Honorable Court is not taking stock of that he has not even been summoned by way of any normal course. And what is cancelled if the bail bonds have not been furnished by him? The bail bonds are being cancelled. It is a mystery before the legal luminaries of this country. And I would like to say that the bail application in the non-bailable offences Once it is held that the apprehension of arrest either at the hands of police or at the hands of court, the anticipatory bail is maintainable, be it the non-bailable offences or the bailable offences. The court is not taking stock of the judgments of the Honorable Supreme Court of India, and I would like to invite the country legal luminaries, if it is a contempt, and contempt in the light of AIR 1972 Supreme Court 2466, wherein the judicial officer or the judicial personnel having 23 years standing in the Odisha cadre was hauled up for contempt of court, and he was removed from the job and service, for which he was not heeding to the verdicts of the Honorable High Court as well as the Honorable Supreme Court of India. The Honorable Supreme Court of India, as per the enunciated provisions of Article 141 of the Constitution of India, says and states that whatsoever the word of the Honorable Supreme Court of India, it is a law of land. And if it is a law of land, the subordinate judiciary is not even caring to heed into. And the Indramohan Goswami's case 2007 Supreme Court says, as and when the non-bailable warrants are issued, before issuing the non-bailable warrants, two situations are to be taken into account. One, bailable warrants are to be issued, or the summons in the normal routine are to be issued. Not at the instantaneous stretch, the non-bailable warrants have been issued. It is putting cause and inconvenience to the public at large. And this Indramohan Goswami's judgment is being flouted by the subordinate judiciary time and again, and there is none who can bell the cat. This is a question before the legal luminaries and we, the people of India. In this video, please share this video, channel this video, and subscribe this channel, Advocate Jagmohan Singh Bhatti. It is in the national interest for we the people of India and for the sake of our national flag, which is furling in high even in this scorching heat. Thank you very much for sharing this video at large.